another that resulted in the birth of a minor son in September of 2021. That
Did you
relation.
want to reserve any time?
Oh, I'm sorry. 3 minutes, please. Thank you. This relationship ended, which resulted in litigation in Robertson County Juvenile Court. The parties were able to agree on everything with the exception of the last name of the child, and that is our sole issue for appeal today. They agreed on a 50-50 plan. They are co-PRPs. The parenting plan, I think this is important later, did provide that their minor child attends school in Greenbrier where mother resides. This is an appeal from a de novo hearing in front of our General Sessions Judge, who's also our juvenile judge, Joel Perry in Robertson County. As you know, the Tennessee legislature has decreed in the state of Tennessee that children born out of wedlock receive their mother's last name. This does not change automatically upon legitimation or paternity and should not be changed without proof that such a change is in the child's best interest. You're all aware of the Barabbas case and the factors that this court has set out for determining whether changing the child's name is in the best interest of that child. And in reviewing those, the first factor, the child's preference, probably doesn't apply. It's a 22-month-old child at the time of this hearing. The change's potential effect on the child's relationship with each parent, the court did not find that that applied. These parents are going to love the child regardless. The child's going to love them regardless. So what we're really focusing on are those last three factors. The length of time the child has had its present name. As I said, the child was approximately 20 months old at the time of the de novo hearing. And what we really focused on were factors 4 and 5. The degree of community respect associated with the present and proposed surname is factor 4, and the difficulty, harassment, and embarrassment the child may experience from bearing either the present or proposed surnames. This court has determined that the proof required for a change in surname is not insubstantial. A parent's preference is not enough. A parent's opinion is not enough, or their belief. So factor 4 is where we spent a lot of time at our hearing, and father put on proof that his mother was the CEO of the Portland Chamber of Commerce at the time, that his father was a deacon in the church and they did certain charitable things within the community, and generally testified that they had a good reputation in the community. I think it's important to note that everyone who testified on behalf of father was a family member. So of course they're going to say that they have a good reputation in the community. No one from the community abroad testified. When father was asked about the benefit of the Ferguson name as compared to Traughber, he answered, "Well, I believe that him having the same last name as his father would be great, because generally when a child doesn't have their father's last name, the assumption is that the father is not involved." He then says that that the child would benefit from kids at school not teasing him because he has a different last name than the father if he keeps the Traughber name. When he was asked if the Ferguson name was better than the Traughber name, he said no. He said, "No disrespect to Traughber. I just feel Ferguson is respected." He could give no reason why the Traughber name would be disrespected. Likewise, the paternal grandmother testified that no one name was better than the other. She just relied on the fact that there's not really a reason not to use the Ferguson name as opposed to the Traughber name. That's not the standard. Father put on no proof as to how it would benefit the minor child to have the Ferguson last name over and above the Traughber name. He put on no proof as to how having the Ferguson last name has even benefited him as someone growing up with the Ferguson name. Mother's testimony was that she worked within the community. Her mother worked within the community. They had a good reputation in the community. I think it's important to note that there is a half-sibling of this child that also carries the Traughber last name. She testified that she does not plan to marry. She's not dating anyone. Everyone in her household has the Traughber last name. The fifth factor that we also talked about a lot, the difficulty, harassment, or embarrassment that the child may experience from either name. As I said, the child has a half-sibling that also is a Traughber. They are close in age. They will be attending the same school together at different times in their scholastic careers. Mother brought up the point that there could be some embarrassment between the brothers not having the same last name. When Father was asked about this, he pushed that aside. He said, "I don't believe it would be the same level of embarrassment or concern as a father's." He's not really concerned about the embarrassment to the child. He's more concerned about the embarrassment to him, not having the same last name as his son. He is concerned that people will think that he's not an involved father because he doesn't have the same last name. I would just propose that the proof will be in the pudding on that. Either he'll be involved or he won't. And so far he has. We hope that he will continue to do so. There's one round of questioning that I'd like to talk about, because I think this sums up everything. Father's asked, "Would you yourself be embarrassed if your son had the Traughber last name?" He answers, "It would affect me." Question, "Okay, would that be a personal embarrassment to you?" His answer, my son not having my name? Yes. Having the Traughber last name? Answer, not being my name? Yes. Question, okay, why would that be embarrassing to you? Answer, because I am his father. And like I stated previously, when a child doesn't have their father's last name, it's typically under the assumption that the child's father is not involved. I'm very much involved. Again, his personal embarrassment is just not the standard for changing the child's last name for a child born out of wedlock.
Counsel, let me ask you this. What is our standard of review? I know it's the person seeking to change the name. It's their burden to show it's in the child's best interest, but the trial court having said they've met that burden, are we reviewing that for abuse of discretion, or is it de novo with or without a presumption of correctness?
I think it's de novo without a presumption of correctness. Okay. So in summation, Father and all his witnesses, all family members testified it was their preference that the name change, but preference is just not enough. They seem to state it would be more beneficial for the child to have the Ferguson name. None of them could point to any specific benefit to the minor child. None testified that the last name Ferguson was any better than the last name Traughber or garnered any additional respect. There was no testimony that there was any negative connotation to the name Traughber. In fact, everyone testified that they had no problem with the Traughber name. Father testified about his embarrassment. That's just not one of the factors that we look at. So it is our opinion that this case should be remanded and that the child should be given the last name of Traughber.
Good afternoon, and may it please the court. My name is Clark Shiflett. I'm a member of the Sumner County Bar, and I represent the appellee, Mr. Brett Thomas Ferguson. Would the court like a brief recitation of the facts Okay, then I can just go ahead and move right on in. Your Honors, we're asking this court to affirm Judge Perry's decision, and by implication, the decision of Magistrate Stark. Although the juvenile court judge arrived at the same conclusion as the juvenile court magistrate, it erred in conducting a hearing considering the change to Tennessee Code annotated 37-1-107D1. Two lower judges arrived at the same conclusion, utilizing and applying the factors of Barabbas v. Rogers applicable to surname changes. This case is about whether or not it's in the best interest of the party's child to have the surname Ferguson. And to that extent, my remarks will center on the procedural aspect of the aforementioned statute and the best interest factors of Barabbas. I would like to note that the case law stands for the proposition that the Barabbas factors are in fact a non-exhaustive list of factors that a court may consider, but the court may consider other things as well, and I'll get into those when I get into my remarks.
Let me ask, you said the judge erred in having a de novo hearing, but in connection with that change, did you read subparagraph 2?
I'm
which
sorry.
says, notwithstanding those provisions, the judge may on its own initiative order a new hearing?
Yes, Judge, I did read that. I think, however, that one of the things that we were trying to make with that specific point, Justice Armstrong, is that this statute was amended to prevent precisely this kind of outcome or this circumstance. Prior to the amendment of the statute on point, it was customary even for a litigant to request a rehearing before a juvenile court judge, and essentially you get a second bite at the apple or another chance at bat. That, for the purposes of judicial economy, was seen by the legislature, I would say obviously, not to be an effective use of our judicial time. And so it is true, a judge could order that, but had the judge done a review of Magistrate Stark's order in compliance with the new statute, I think it would have made unnecessary the need for a second hearing. Because, and I think this is one of the reasons that it was appealed in the first place, because under the new standard, that magistrate's decision in her ruling is reviewed upon an abuse of discretion. And so that's a pretty high burden, and only where a judge finds that there has been an abuse of discretion do we move forward with changing it. Does that respond to your question, Justice Armstrong?
It does. Well,
Thank
let
you.
me ask you, looking at the record, what would you cite us to support your argument that you met your burden to show that changing the name to the father's name was more beneficial? Because
Certainly.
part of the transcript that I read, it appeared that the father's focus was on the fact that since he was an involved father, the name should change. That's really what he feels based on my review of his testimony.
Mm-hmm.
And that, of course, is not a basis to change the name.
Absolutely not, Your Honor. I think that it would be helpful for the court to consider, however, that much of that, so the father had the burden. Under the Barabbas case, the father has the burden of showing that it's in the best interest of the children. So to that extent, it was his burden to produce evidence to show that. Much of the testimony that is being discussed with respect to preference, and by the way, let me just pause there and say, I don't think the father is trying to run from anything, and it would be dishonest and perhaps disingenuous for him to say, no, it wouldn't bother me at all. Clearly, it bothers him. The question is not whether it bothers him per se and whether that's the basis for making the name change. The question is, did he carry his burden under the Barabbas factors and the other things that a court may consider with respect to the best interest of the child? So we're not running from the fact that he might be embarrassed by that. I would also add that that came, and that particular testimony came on cross-examination. It was not part of his case in chief. So the proof that he put on, I think, is substantial in the sense, and I could go directly into the factors if the court would like me to do that.
Go ahead.
So with respect to the Barabbas factors, I think everyone agrees that the first two don't apply. The third one only minimally applies because of the tender age of the child at that time. The fourth had to do with the degree of community respect associated with the present and proposed surname, and this was admittedly the central focus of much of the testimony before not only Magistrate Stark, but also before Judge Perry. All parties agreed, and I think this is notable as well, that the Ferguson name was notable and commendable. Your Honor,
But didn't they agree the same with the Traughber name? I mean, it seemed to me like basically you had both sides kind of saying, there's nothing wrong with Ferguson, there's nothing wrong with Traughber. They both have ties to the community, they're both respected, all good. Dad wants his kid to have his name, mom wants the kid to have his name, and if that's the situation, is the burden met?
well, respectfully, Justice Davis, what I think is that when we look at the proof that was adduced at trial, what you see is it's not just a matter of Dad just wanting it. We put on specific proof at trial that showed an extensive amount of volunteerism by the father's family. We had testimony from the paternal grandmother, paternal grandfather, and my client himself. And the proof adduced was that the reputation itself, by itself, was commendable and notable across multiple counties, that it was widely known and recognized. The appellant admitted the same on cross-examination. I think it's also important to note that in the Keith case that we cite, only one grandparent testified in that case, and that was sufficient for that court, this court actually, to find that the burden had been met. So it's not really just a matter of he wants it. One of the things that we showed about the Ferguson name at trial specifically, and one of the reasons that I believe that Magistrate Stark said that it would be undoubtedly beneficial to the child, was that the Ferguson name showed considerable social and professional contacts, including community and state leaders, that is to say mayors, House members, and senators. There was extensive volunteerism that was testified to with respect to community events. There was work with area schools and other chambers and leadership programs, most notably Leadership Portland, Leadership Robertson County, and Leadership Middle Tennessee, I believe it was. The existing reputation with the Ferguson name as being reputable and notable and commendable was supported by all of those contacts and all of those associations. And by the way, let me pause there and just say, we didn't have to tear down the Traughber name. That was not our burden. It was not our burden to somehow, and it's also curious that we require parents to co-parent in a harmonious way, for example, and then when they kind of go at each other's throats to some extent by trying to tear each other down. We weren't trying to tear down the Traughber name, and that wasn't our burden. Our burden was to show that the Ferguson name specifically it was just a little bit more, could offer a little bit more to the child. And I think, to speak to Justice Armstrong's concern with respect, I think there's a necessary implication in there. When you have all of these contacts, when you have all of these kinds of associations, when the name that you carry is associated with military service, strong church participation, a long-standing residence in the surrounding area, significant job stability, the existing reputation, which I've already discussed, and those contacts, when that child carries that name, it is undoubtedly a benefit to the child.
Do they live in the same community, Counsel?
That's a difficult question. Yes, Your Honor. They were both at one point in Robertson County. I believe Mother is still, and obviously I would have to check with Mr. Johnson, but I believe she is still in Robertson County. Father may have be now right on the edge of Robertson County.
So you say that they maybe live in the same county, but not the same community.
Not the same community. And I think that's telling, especially with respect to the Ferguson name, because Judge Perry specifically found that the reputation was beneficial across multiple counties, not just Robertson County, but across Robertson County and Sumner County.
And so having that name will do what for the child?
Well, I think for one thing, it'll open doors. And again, I think that's an implication, but it is not the burden for us to show every potentiality or every possibility that could occur. But if I may draw it's so dangerous to talk about political names, but there are certain names that we know on a national level, and if your name is that, or if you have that name, it can open certain doors for you. I don't have to get that grandiose when I talk about a name on a community level or in a Central Tennessee or Middle Tennessee type thing, but the analysis is the same. If the name is well known in that geographic area, then it can open doors. It can help the child out. I want to make sure I've sufficiently answered your question,
Well,
Justice
you've
Harper.
responded to it.
All right, thank you.
The answer is
Well, perhaps not answered it
different
then.
question. Okay.
Well, and I think if we step back for just one moment and we consider what is the burden, what is it we're asking a litigant to prove when we're trying to suggest that one name is better than the other? There are necessary implications with that. We can't avoid that. We can't, by the way, we can't shoot down a litigant's preference as something that is fatal to their petition. I think any father or any mother that wanted a child to have their last name would potentially be embarrassed by it. So I don't see that as a particularly telling bit of testimony that came on father's behalf at that time. But we require litigants to look at these factors and to present a case based on these factors. In addition to the factors, however, I think one of the things that we've pointed out was that, and since we're talking about embarrassment, I'll go on to the fifth factor. I know my time waxes thin, so I want to make sure I get to at least the fifth factor. The difficulty in harassment or embarrassment. Your Honors, I think what is really, really important for this court to understand is that, again, we didn't do a recitation of the facts, but we did have a hearing on the merits in front of Magistrate Stark. And at that hearing, the central issue was not whether or not the child should have the Ferguson name. It's whether or not the name should be Traughber-Ferguson versus Traughber-Ferguson with no hyphen. That was the central issue in that case, and in that hearing, let me say. When we get in front of Judge Perry, that is ostensibly jettisoned by the appellant. So a lot of the testimony that originally came in front of Magistrate Stark had to be resurrected to some extent, and the appellant even admitted at that point in front of Judge Perry that she was not opposed to Traughber-Ferguson, provided there was the use of a hyphen. Of course, the testimony in front of Magistrate Stark was that that would be a name of a tremendous number of characters on standardized tests that would create problems for the child. That really speaks to the fifth factor of Barabbas. But that's kind of what happened and why some of those things came in. So when we were talking about the potential embarrassment to the child, we were dealing with what I'm going to call a switcheroo in that hearing before Judge Perry. My client's concern, the appellee's concern, was that we would have this name that would be of a massive length. Magistrate Stark didn't think that was in the best interest of the child either, and one of the things that she said with respect to the use of not using a hyphen, and I think this court should consider this, only because Magistrate Stark took the position she didn't have jurisdiction to enter a name without the use of a hyphen. She essentially took the position that if it were Traughber-Ferguson without a hyphen, then Traughber would be relegated to a middle name and not a last name. And so she didn't believe she had jurisdiction to do that, but she did believe she was authorized to make the name Ferguson, and that's what she ultimately decided to do. Much of the same proof that was in front of Magistrate Stark is the exact same proof that was in front of Judge Perry. And so it was literally like we did it a second time. It was almost like deja vu.
Do you agree that our standard of review is de novo with no presumption of correctness?
I'm going to say yes, Judge, I think so, except that when we talk about that procedural aspect that we raised in our brief, because that is going to have to be a different standard of review, Your Honor. But yes, I would agree that that is the standard of review. With respect to the procedural aspect, I think it's going to have to be an abuse of discretion standard. But with respect to what Judge Perry did, if this court were to somehow remand, and by the way, I'm not hopeful that the court remands so that Judge Perry can simply enter an order where it states that he has reviewed the magistrate's order and finds that there are no, there's no abuse of discretion. I think that's what should have happened. And other than the fact that my client was forced to incur additional attorney's fees for putting on the same proof twice, I think that the error itself was harmless, except to the extent that he had to incur additional attorney's fees to fight that. The almost universally accepted practice in the area, and there was testimony to this effect with respect to the embarrassment issue, and I think that's exactly, if the transcripts, if your honors review the transcripts, you will see that the almost universally accepted practice in that area, and that being Robertson County, Sumner County, and even moving down here into Davidson County, is that children do carry the father's surname. Now, I understand that doesn't necessarily square with what the case law says and what the cases, the historical cases say, but it is nonetheless the proof that was adduced at trial. Your honors, I hope I've answered your questions, or at least responded to them. We're simply asking the court to affirm the decision of Judge Perry. We would also ask for an award of attorney's fees.
In regard to what they do here and in Robertson County, where they change the name to the father's name, you know that under the statute, that's not necessarily lawful.
I'm not sure I understand your question, Justice Armstrong.
Under the statute, a child born to an unmarried woman will carry the woman's name, not the father's name.
That is correct.
So it doesn't matter what they do in juvenile court where they automatically change the name to the father's name. That actually shouldn't happen, should it?
If the court is, if your honor is asking me if the juvenile court is empowered to conduct a best interest analysis and change the name only if it finds, after application of the Barabbas factors, that it's in the best interest of the child to change the name, then I would disagree with your honor. I think the court
But is that what they're doing in these counties that we just talked about? That they're looking at all of these factors, or are they simply changing the name?
Well, I think in this case specifically, Your Honor, that they looked at the factors. The factors themselves were paramount in Magistrate Stark's mind and Judge Perry's mind. They literally went down categorically and discussed them.
Okay.
So they did. I think that they did do a Barabbas analysis, and that's in the written record as well in the decisions issued by the court.
Are you just saying in general, children generally have the last name of their father? Is that what you were saying?
Yes, and I think that's what the testimony was as well, Your Honor.
Okay.
Thank you.
Your Honors, I would,
You have 3 minutes.
okay, sorry. I would disagree that it's the general practice for a child born out of wedlock to have the father's name. I don't think that's the case. I think sometimes it gets litigated, but I have a bunch of clients who have children born out of wedlock with mother's last names. I don't think that's the common practice at all. The other thing, with regards to the law change, first of all, we appealed from a de novo hearing. I don't think it's necessarily relevant what Magistrate Stark did. We don't have her transcript. We have Judge Perry's transcript. That's what we've been working off of. The ruling came down on 12/27 of 22. Part of that ruling was a notice of appeal, or notice concerning appeal, that gave us instructions of what our options were. That was part of the order. We filed our notice concerning the appeal the very next day. On January 24th, the judge granted our rehearing, set the rehearing date for March 23rd. It was continued once at the request of father, with a new hearing date set for 4/14 of 23. Was continued once at the request of mother due to a doctor's appointment with the child, set for hearing on 5/11. The new law change took effect on 5/3. It's our position that mother had a vested right at this point in time. This was not just a procedural matter. This was more substantive. And we just don't think that it's the law that she would have her right cut out because the final hearing got delayed a couple of times, 5 days past when the law took effect. With regards, I think it was Judge Armstrong who asked what would be the effect of the Ferguson name. I think that's part of the problem. There was no real proof as to that, other than she is a CEO of a Chamber of Commerce and a lot of people know her, but no proof as to what doors would open, anything of that sort. So we just don't feel like the father is met his burden in this case. I thank you for your time and attention.
Thank you. Thank you for your oral argument. We'll take the matter under advisement. and render an opinion as soon as possible. Thank you. We call the next case.
In re Estate of Richard Wayne Penniman